All right, CA Foundation students, listen up. This explainer is absolutely for you. We're diving deep into a super important chapter, the performance of a contract. We're going to break down everything that happens after the deal is signed. So let's get right into it. So you've done the hard work, right? You've negotiated the terms, you've put your signature on the dotted line, the deal's done, or is it? The obligations are set, for sure, but the story is far from over. In fact, the most important part is just getting started. Yeah, not even close. A contract is so much more than just a piece of paper. It's a promise of action. The real test, the part that actually matters, is in the performance. This is where promises have to become reality. So let's walk through exactly how that works. Okay, so first things first, let's get to the absolute core of it. When the Indian Contract Act talks about performance, what are we really talking about? It sounds simple, I know, but trust me, the law has some really important distinctions we need to nail down. And there you have it, straight from the source, Section 37. At its heart, performance is just doing what you said you were going to do. It's all about fulfilling those obligations and turning the words on the page into actual real-world action. Now, this is a super important distinction you've got to know. You've got actual performance, pretty straightforward, the job is done. But then there's attempted performance, which is also called a tender. Think about it. You show up with the goods, on time, at the right place, and the buyer just says, nope, don't want them. That attempt to perform still has real legal weight. It's a big deal. Okay, so we've got the what down. Now for the next logical question, the who. Who actually has to perform the contract? Can you just hire someone else to do it for you? And what on earth happens if the person who made the promise isn't around anymore? Let's figure out who the key players are. So the Act gives us a few options. Of course, the promisor themselves can do it, or they can use an agent. You can even have a third party step in as long as the other side agrees to it. But here's a key point for your exams. If the promisor passes away, their legal representatives have to step up. The catch is their liability is limited only to the value of the estate they inherit. And this is the perfect example to lock that idea in. If you hire a famous artist to paint your portrait, you're paying for their unique skill, right? Their talent. They can't just send their apprentice over to do the job. When a contract involves personal skill, it has to be performed by that specific person. No substitutes allowed. All right, now let's zoom in on a hot topic for exams, joint promisors. This is when you've got multiple people, 2, 3, maybe more, all making one single promise together. How does that work? Well, the rules are very, very specific. This whole concept is called joint and several liability, and you can think of it as a 3-step process. Step 1, the person they made the promise to can go after any one of them for the entire promise. That's right, the whole shebang. Step 2, the person who paid up can then turn to the others and say, all right, everyone, time to chip in your fair share. And step 3, what if one person can't pay? Well, the remaining partners have to split that person's share of the loss equally. They are all in it together. Okay, what and who? Check. Now for the nitty-gritty details. The how, when, and where. What happens if the contract is totally silent on a deadline or a location? Does it just hang in limbo forever? No way. The law has a backup plan, a clear rule book for these exact situations. Think of this table as your ultimate cheat sheet. The big idea here is the word reasonable. If the contract doesn't give a time, it must be done in a reasonable time. If there's no place fixed, the promisor has to ask for a reasonable place. The law basically injects common sense into the agreement to make sure things get done fairly and practically. Now we get into the really fun stuff, the twists and turns. These are the kinds of complex scenarios that can really trip you up on an exam if you're not ready for them. Let's kick things off with a classic. What happens when you owe someone multiple different debts? This is called appropriation of payments, and there's a clear pecking order. Rule 1, the debtor gets first say. They can specify, hey, this payment is for the May invoice. But if the debtor stays silent, Rule 2, the power shifts to the creditor. And get this, they can apply the money to any lawful debt, even a time-barred one that's too old to sue for. And finally, Rule 3, if nobody says anything, the law steps in and applies the payment to the oldest debt first. Another common twist you'll see is reciprocal promises. This is your classic, I'll do this if you do that kind of deal. You know, one person promises to deliver the goods, the other promises to pay. The order in which these promises have to happen is absolutely critical. And the principle here is usually just common sense. The nature of the deal itself dictates the order. A builder has to actually build the house before they can expect the buyer to pay for it, right? One promise is completely dependent on the other one being finished first. So we've talked a lot about fulfilling a contract, but what about ending it? A contract's life isn't meant to last forever. This final section is all about crossing the finish line, the different legal ways a contract can be discharged, which just means the obligations have officially come to an end. Now, performance is the most common way a contract ends, but it's not the only way. As you can see, a contract can also be discharged by mutual agreement if it becomes impossible to perform, if there's a breach, or by operation of law. Let's take a closer look at a couple of these. Okay, let's focus on discharge by mutual agreement, because it has two terms that are so easy to confuse, but they're an absolute favorite for examiners. What is the real legal difference between novation and alteration? Getting this right is absolutely key. Here's the key difference, and it's simpler than it sounds. Novation is all about substitution. You're swapping the old contract out for a brand new one. Sometimes the parties might even change. Alteration, on the other hand, is just a modification. You keep the original contract, but you tweak some of the terms. So think of it as replacement versus an edit. A contract can also end if it becomes impossible to perform. Section 56 talks about two types. There's initial impossibility, which means it was impossible from the very beginning, like a contract to discover treasure by magic. But what's more common is subsequent or supervening impossibility. And this is when a perfectly valid contract gets derailed by some unforeseen event. For example, the law changes, and suddenly your deal is illegal. Or the specific thing you were going to sell gets destroyed. Or in a skill-based contract, the promiser becomes incapacitated. When these things happen, the contract becomes void. So as you can see, a contract is so much more than just a static document. It's a living, breathing obligation that has to be performed by the right people, at the right time, and in the right way. And if it can't be performed, it has to be discharged properly according to the law. And that leaves us with one final thought. We know signing a contract creates a legal obligation, but when is it truly complete? Is it when the letter of the law has been met and all the boxes are checked? Or is it when the actual purpose, the true spirit,